As a constitutional law attorney, former senior legal advisor and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Hello, friends, and welcome to another episode of the Jenna Ellis Show. I'm Jenna Ellis, and today we will be covering the legal analysis and breakdown of the Moore versus Harper opinion from the U.S. Supreme Court that was handed down yesterday that was specifically discussing the Elections Clause in Article 1, Section 4 of the U.S. Constitution. So I want to get into the legal analysis of that, but then also the wider discussion of this concept called judicial review. The Supreme Court tends to think that it just can opine and issue opinions on questions and issues that it wants to discuss. But that is not what the U.S. Constitution actually grants in terms of specific limited power to the judiciary. So how do we understand this? Well, my good friend John Hostettler, who is a former member of Congress, and he wrote the great book Ordained and Established, joined me this morning on radio to discuss the specifics of the case. And I want to play that audio for you in case those of you who listen just on Salem on the podcast side missed that, because I think that conversation was really important to set up then what we're going to talk about further in the wider scope of judicial review and what I'm starting to call being led by a juristocracy, or this whole idea that the Supreme Court is our tyrant now instead of being under a constitutional republic. So we're going to talk about all of that and more. So this is the audio from that interview. Listen to this. So the Supreme Court issued an opinion yesterday, several in fact, but we're only going to talk about one of them that was very important. And this is Moore versus Harper, if you are interested in going and actually reading the opinion for yourself. But this dealt with the Federal Elections Clause in Article 1. And the holding of the court is that the Federal Elections Clause does not vest exclusive and independent authority in state legislatures to set the rules regarding federal elections, and therefore did not bar the North Carolina Supreme Court from reviewing the North Carolina legislature's congressional districting plans for compliance with North Carolina law. So this was a 6-3 opinion, and if the opinion of the justices and who was in the majority and minority gives you any indication of what I think about this case, know that Chief Justice Roberts wrote the majority opinion, and the three most conservative justices, in my opinion, on the court, Thomas, Alito, and Gorsuch, were all in the dissent. So joining me now to talk about this more and break down what this actually means for future elections and also the concept of judicial review is John Hostettler, who was a former member of the U.S. House of Representatives and the author of the book Ordained and Established, A Statesman's Citizen's Guide to the United States Constitution. So good morning, John, and thank you so much for joining me this morning.
Good morning, Jenna. Thank you for having me.
Yeah, I really appreciate this. And so just first overall, with this particular case that we're dealing with, Article 1, Section 4, which for listeners, that section is the time, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations except as to the places of choosing senators. So this is the section that the Supreme Court case is contemplating. And basically the North Carolina Republicans, their argument was to say that the state legislature, basically has plenary authority under the U.S. Constitution, and state law can't get in the way of that, and so they have this idea that this is actually power given to the state legislature that can't be foreclosed by another law to the state, so or by the state or by the Constitution. So in terms of how you read the majority opinion, I don't think this is a great opinion, but what is your take on this overall?
Well, it's not a great opinion, and my view of that is not the first time for me. When I was in Congress, I took umbrage with a lot of what the federal judiciary did on several occasions. And I think, you've read the clause in Article 1, Section 4, and in fact it does do exactly what the Supreme Court and the state Supreme Court said it doesn't do, and it does vest exclusive authority in the state legislatures to draw maps in this particular case. It would be under the manner of holding elections for representatives, and that's what it does. But Jenna, what's most troubling to me, but not completely unfamiliar, is that it's what the federal judiciary, the Supreme Court, left out of its opinion, and that is any reference to the Supremacy Clause, which is in Article 6, because Article 6 solves this problem. It answers the question that the court ostensibly is making in this, and the court is basically asking, first of all, does the state legislature have exclusive authority? If you look at Article 1, Section 4, the answer is yes. And then it asks if the state courts can intervene, or, in my opinion, interfere in this exclusively vested authority in the Constitution. Article 1, Section 6, Clause 2 is what's known as the Supremacy Clause, and it says very clearly, it answers this question very clearly: this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And this is the important part: the judges in every state shall be bound thereby. Once again, bound by the Constitution in this case, in this case that we're talking about this morning. And then it goes on to say, anything in the Constitution or laws of any state to the contrary notwithstanding. So the court is asking basically, does the North Carolina state legislature have exclusive jurisdiction? Article 1, Section 4 answers that. Can the judges in the state, in North Carolina in this case, can they, according to their Constitution or their laws in the state of North Carolina, can they disregard that particular exclusive authority? And the Constitution clearly says no. And so the Supreme Court seeks to, and some commentators, I'm sure you've read, have suggested this, is that the Supreme Court is continuing to assume more authority in all kinds of areas. And in this particular case, we can see very clearly that not only does the Supreme Court not have authority in this, but the state courts can't have authority in this either.
And that's just so well stated, John. And I'm talking with John Hostettler, who was a former member of the U.S. House of Representatives and the author of the book Ordained and Established. And John, so then how did the Supreme Court arrive at their majority opinion and just totally disregard the rules? I think that's what's so frustrating when all of us who are conservatives see activism on the Supreme Court, where they're just disregarding the rules and fabricating their own opinion and basically suggesting that we live in a juristocracy instead of a constitutional republic that has supreme laws.
Well, that's the $64,000 question, Jenna, and it comes in the syllabus. In my opinion, to answer your question, in the syllabus, Roberts, in my opinion, is a little tone deaf whenever he cites the same case, the same precedent, if you will, that every other court has cited before this time when they seek to interfere in constitutional areas that are clearly not their jurisdiction. They cite Marbury versus Madison, as Chief Justice Roberts did here. But just like Chief Justice Marshall did in Marbury versus Madison, when he left off, when he put a period in Article 3, Section 2, where the Constitution puts a comma, and he left off the rest of that section, the United States Supreme Court just decides to disregard Article 6. And so the idea is that the Supreme Court has an outcome that they want. And once again, this is a layperson's opinion. It's my observation that the Supreme Court decides that they want a particular outcome. In this particular case, they wanted to assume more authority over state legislatures in the drawing of congressional maps, to assume more power over the federal legislature, if you will. And so they had their outcome, and they drafted an opinion to suit that outcome. And in drafting that opinion, they could not make any reference to Article 6, because that would have been contrary to their outcome. It would have dispelled any notion that the court or the state courts could do anything in this matter. So I think this is just something that the framers knew was a possibility. Thomas Jefferson railed against the potential authority that a life tenured federal judiciary could assume to themselves. But in my opinion, the framers did put guardrails up, and we've been given a written constitution. We can read it ourselves, and we can read this opinion ourselves, and we can say, well, wait, this part is completely contrary to the Constitution. That part is completely contrary to the Constitution. So they're trying to assume more authority, and we need to stop that.
We do need to stop that, and that's exactly, you're absolutely right, John, that this is what the Supreme Court does when they want an outcome-based resolution that they don't actually have the authority for. And in what I thought was yet another beautifully written dissent by Justice Thomas, his first line is, "This court sits to resolve not questions and issues, but cases or controversies." And he's making the assertion that they're not following their limited jurisdiction and authority in Article 3. And so they've been doing this for decades, just assuming that the authority that they don't have under the Constitution to get to an outcome that the majority prefers. So we do need to stop that. And what is your opinion on the best way to do that? Because this now is the opinion from the bench. It's clearly wrong. So what's the resolution?
Well, one of the means that I chose to attempt to solve these problems, to resolve these issues, was by what the framers referred to, the Federalist paper writers referred to as the power over the purse. And that is, and I'll give you an example. For example, when the 11th Circuit, back in, I think it was 2003, if I recall right, when the 11th Circuit sought to order the removal of the Ten Commandments from the Alabama State Supreme Courthouse that Chief Justice Roy Moore had placed there, I offered an amendment to the appropriations bill, the relevant appropriations bill, the Commerce State Justice Department of Justice appropriations bill, which funded the federal judiciary, and just basically said no money may be expended for the enforcement of any order pursuant to that particular opinion. So, you know, in practical sense, what would have happened was, if ultimately the Alabama State Supreme Court had it removed, they removed Chief Justice Moore, then they removed the Ten Commandments, unfortunately. But what would have happened on the federal level is an order would have been issued by the 11th Circuit, and the federal executive branch, under the authority of the U.S. Marshal Service, would have contracted for the removal of that. Well, if you stop funding that process can't go on. And so the appropriations process is a way, and is the fastest way, in my opinion, to stop these errant decisions from becoming made in practice.
And that's one of the, as you said, the quickest and best resolutions, and that's an idea that Governor DeSantis has been talking about quite a lot on the federal level as well, and from his time in Congress has seen that also as a solution. And in just the last about 3 minutes that I have with you, John, I also want to get your commentary on the concept of judicial review as a whole, because I think this idea in the conservative mind really doesn't jive with what the Constitution actually does provide in Article 3. And I've long been an advocate to reinterpret Marbury and to say, really that case set us on a really bad track, and it needs to, this whole concept of judicial review really needs to change in terms of the way that the Supreme Court exercises it.
Well, yes, I agree completely. And, Jenna, we need to actually kind of do a crash course on not only Marbury versus Madison, but the history behind it. And the fact, as Dr. Lewis Fisher from the Library of Congress has pointed out, that after Marbury versus Madison, for the next 32 years that John Marshall was Chief Justice, the Supreme Court never again overturned a congressional act. And it was because of, the impeachment of Samuel Chase and all those other things that happened subsequent to Marbury versus Madison. And when the legislature, and in the case of Marbury versus Madison, the executive, decided to disregard what the court was attempting to do is important. Now we're not talking about an assault on the so-called independence of the judiciary. The court can say whatever it wants to say, but in what Jefferson referred to as the spheres of action of the legislative branch, the Congress doesn't have to fund these stupid opinions. And what Hamilton said about the judiciary needs to be understood by an executive, and that is that the court's power is, he said, merely judgment. And the court ultimately depends upon the aid of the executive arm, even for the efficacy of its judgment. So a president can disregard in his executive capacity these errant opinions of the court and simply refuse to execute any orders pursuant to them. Once again, that doesn't stop the judiciary from judging. It just doesn't make the executive branch obliged to take part in these
right.
decisions.
And that makes so much sense. And John Hostettler, really appreciate it. You're going to be on my podcast later this afternoon. We're going to dive deeper into this. So I'd encourage everyone to listen to that. TheJennaEllisShow.com. We'll be right back with more here on Jenna Ellis.
All right, so that was my interview with John Hostettler this morning on radio, and we'll be right back to continue the conversation with a brand new commentary and comments with John Hostettler right after this. With inflation, the banking world collapse, and everything that Joe Biden is doing not to protect America, you need to make sure to secure your financial health, especially in retirement. And hey, if you're a millennial like me, that actually is sooner than you think. You need to start now, even if you are a millennial or a Gen Zer, to make sure that your financial health is actually healthy when we get to retirement. And Legacy Precious Metals has a revolutionary new online platform that allows you to invest in gold and silver online in real time. In a few easy steps, you can open an account online, select your metals of choice, and choose to have them stored in a vault or shipped right to your door. You'll have access to a dashboard where you can track your portfolio growth in real time anytime. You'll see transparent pricing on each coin and bar, and this puts you in complete control of your money. The platform is free to sign up for. Visit legacypminvestments.com and open your account and see this new investing platform for yourself. Gold hedges against inflation and against a volatile stock market. A truly diversified portfolio isn't just more stocks and bonds, but different asset classes. This brand new platform allows you to make investments in gold and silver, no matter how small or large, with just a few clicks. Visit legacypm.com to get started. You can download the free investor's guide, and you can also call Legacy PM Investments to talk to a portfolio expert to get expert answers to your to customize your personal portfolio. So visit legacypminvestments.com to get started. Tell them that Jenna sent you. So joining me now to break this all down and talk more about the Supreme Court and the Constitution and the concept of judicial review is John Hostettler, who is a member of the U.S. House of Representatives and also the author of the really excellent book, Ordained and Established. So John, thanks so much for joining me. And you were on my radio program this morning, and we only had one segment for that. There's so much more I wanted to get into. So I know a lot of my radio listeners have anticipated this podcast as well and have reached out to me. So thanks so much for giving me the opportunity to speak with you twice in one day.
My pleasure. Great to be with you again, Jenna.
Yeah, thanks so much. So let's go back and talk about your thoughts about the Moore decision today or yesterday rather, and what exactly the Supreme Court in the majority got wrong.
Well, unfortunately, the more I read it, the more I realize just how much they got wrong in that they were looking at the clause, the elections clause, that gives express authority to the state legislatures to determine the time, place, and manners for electing the House of Representatives. The same is the case for the senators, but this case deals with the districts that are created by states in manning the United States House of Representatives. And so while they address that issue, and that's their rationale for getting involved in this in the first place, they have a very the justices have a very interesting perspective on what they should be doing. And let me just read from Justice Roberts' opinion when he says this very interesting thing. We decide today whether that clause vests state legislatures with authority to set rules governing federal elections free from restrictions imposed under state law. So if you think about this, the Supreme Court, the federal judiciary, is inserting itself in what's really a political controversy on the state level, meaning the states, the legislatures have been given clear authority in the United States Constitution to do this. Ultimately, and we'll talk about this also, ultimately, a court decided that individuals who were not affiliated with the legislature would actually draw the maps for the most recent midterm elections, which is completely unconstitutional. So the court has inserted itself there and talking about state laws. But as I mentioned to you earlier today, there's no discussion at all in this opinion, and quite honestly, not even in the dissenting opinions, about Article 6, and specifically the Supremacy Clause that says this Constitution, the United States Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And this is the important part for our discussion. And the judges in every state shall be bound thereby, meaning the judges in the state of North Carolina are bound to the United States Constitution. There's also an oaths clause that comes after this, but they're bound by the Constitution. Then it goes on to say, anything in the Constitution or laws of any state to the contrary notwithstanding. So the question is answered for Chief Justice Roberts when in the Constitution itself, when it says it doesn't matter what the state constitutions say. It doesn't matter what state laws say. It's what the Constitution says expressly with regard, in this case, who draws maps, for example, and that is the state legislature.
And this seems so clear, John, that the text of the Constitution provides the plenary authority to the state legislature, and nothing in a state constitution or a state law notwithstanding can override that. And when we had that discussion this morning on radio and you mentioned the Supremacy Clause, I thought that is really interesting. And I actually went back and read the dissent from Justice Thomas, which Alito and Gorsuch joined, and there wasn't any discussion in that. And that actually surprised me, because when once you mentioned it, that should have been a very clear basis, or at least within, I would have thought, within the context of the dissent. And so here, when you have the dissent, basically it was a question of mootness for Justice Thomas, and saying we only have jurisdiction over actual cases and controversies, which is the text of Article 3. And he said, so courts don't issue what are called advisory opinions or ask and answer questions and issues. They're not policymakers. And that's really what Chief Justice Roberts and the majority became in this case. And that was more the argument of Justice Thomas, which I think was also brilliantly stated and absolutely true as well on a separate basis. But it seems like that question about the Supremacy Clause, at least insofar as we want to make sure that that precedent is discussed and put into this opinion, why do you think that wasn't mentioned in this context, at least in terms of saying if the court were to have reached the merits without respect to the mootness question? And I get that, he was saying we shouldn't have even had to bring this up. The writ should have been dismissed on face. But even if we could have reached the merits, here was the clear opinion.
Right. Well, speaking as a layperson, Jenna, on this issue, but someone who's confronted this issue of separation of powers when I was in the House of Representatives, often it seems that in the study of the law, so much is placed on precedent. And I learned something really interesting in my second term, if I can just share a little bit of history with you. And that was a law school professor came up to the Hill to provide testimony on a topic that was being discussed by the Judiciary Committee, a specific subcommittee of the Judiciary Committee. I had testified as a member of Congress on a particular bill I had as a member of a panel prior to a second panel coming before and testifying. And when the second, so there was a set of us members that had bills dealing with the subject matter before the subcommittee. Then they brought in the smart people, the second panel of academics, to talk about this issue. And the specific issue was referred to as judicial misconduct. And one of the academics, Professor Lino Graglia of the University of Texas School of Law, said something that was very interesting to me, a layman, and helped me understand all of this in a couple of sentences. And that is, he said this: the first and most important thing to understand about constitutional law, as a constitutional law professor, he taught constitutional law at UT, and he said, the first and most important thing to understand about constitutional law is that it has virtually nothing to do with the Constitution. And he went on to elaborate on that and discuss that. And, if we kind of harken back to a couple of weeks ago, Jenna, I'm sure you saw that the nomination hearing in front of the Senate Judiciary Committee, where a Biden nominee for, I believe it was a federal district court, was asked what the subject matter of Article 5 was. And when she couldn't give an explanation of what Article 5 was, which is, Article 5 is the amendment, the authority and that sort of thing, states convention, that sort of thing. So that's kind of, you might say, in the constitutional weeds, I guess. But then she was asked about Article 2. What is the subject matter of Article 2? And she couldn't answer that. She said nothing came to mind with regard to discussion of and I don't want to impugn all attorneys. I have friends who are attorneys. I have family members who are attorneys. However, my understanding is, having worked with, and you would be much better capable of elaborating on this than me, is that so much is decided on precedent. And so you have to keep looking at previous cases, and there are case books, and you look back through previous cases to build an argument. And so you don't really, I say you. So a lot of attorneys don't necessarily learn the Constitution in their education. I had a colleague, and I'll stop rambling about this, but I had a colleague that told a staff member, and it was the staff member several years later relayed this to me. And there was a question before the Committee of Jurisdiction, and this former colleague looked at his staff member, who was a personal friend of his as well, and said, you know what, I don't remember studying the Constitution when I was in law school. I mean, it's just kind of a, mea culpa or something like that. But I say all that to say that whether it's an opinion or a dissenting opinion or a concurrence, my experience is that we talk a lot about previous cases, previous precedents, and not so much on the Constitution itself.
That's absolutely true. And I experienced the exact same thing going through law school. And it wasn't at all that I had an inferior education or, that my professor didn't know what they were talking about or anything like that. But it's true for the vast majority of law schools. I can only think of maybe Regent or Liberty University now that actually teaches some of the history and the text of the Constitution, but that is very outside of the box thinking, unfortunately, for law schools, because law schools do teach you how to pass the bar. That's really all that they're there for. And so how do you pass the bar? Well, you learn the substantive doctrines of what the court has interpreted the constitutional text to mean. So when I went through a constitutional law class in law school, I had actually read the text of the Constitution prior to that, gone through that only because our mutual friend, Mike Ferris, who was at then the co-founder of the Homeschool Legal Defense Association, he actually created a constitutional law program for high school students. And I went through that in my high school homeschool studies. And so I had an awareness of the text and the history before I went to law school. In law school, constitutional law class starts with Marbury versus Madison, which is a topic that we'll discuss today as well, and saying, okay, so this concept of judicial review, which is nowhere in Article 3, and Article 3, which covers the federal judiciary, one Supreme Court, and all such inferior courts as Congress will establish, that is limited to actual cases and controversies. But Marbury has been so far extended to say basically anything that the court wants to opine on and wants to decide, it can fabricate or find jurisdiction basically out of thin air. And that's the doctrine, not in so many words, but that's basically what law schools teach. And so you learn the substantive doctrines, and we're teaching future students to then who become lawyers to go into courtrooms and to argue based solely on precedent. And this whole body of what we call constitutional law is completely separate and almost purposefully divorced from the text. And so when I've seen other advocates go into situations like this one, in this case that we're talking about, or even the Dobbs opinion, and it's mind-boggling to me that they're only arguing based on past controlling precedent instead of saying the Constitution itself is controlling. And so if there is an opinion that violates the text, or was, as the Roe versus Wade opinion was, fatally flawed in its inception, then we have to go back and be faithful to the original text. And I think very few of the justices actually have that model. And if I were sitting on the Senate Judiciary Committee, that's exactly what I would be asking nominees to the federal bench at any level, and certainly a future Supreme Court justice. Because what it seems like now, and I think this opinion yesterday is really evidence of this, the justices want an outcome-oriented decision, and so they just shoehorn whatever they want into their ability to then opine as an activist outcome-oriented decision instead of being faithful to the text. And that's why we've gotten so far off. I mean, imagine if this were in a church situation. Nobody ever reads the Bible. It's only whatever doctrines certain pastors or people who have been great theologians through the centuries have established and opined, and we only can appeal to their theological doctrines based on proof texting one verse or one chapter of scripture without even reading or teaching the entire full text of scripture, we would be totally lost. And that's what we're doing in the context of constitutional law. So I think you're right to draw attention to that. That was my experience. And part of what has frustrated me in even my representation of former President Trump, my representation of other churches during the midst of the COVID pandemic, a lot of these that have been in the media, and then certainly, a ton of other cases that the media will never care about. What I've been really frustrated with is that exact model that lawyers are expected to appeal only to precedent in crafting their arguments instead of the text. And so this whole concept of judicial review, I think, has been so bastardized and misplaced and perverted. And even Marbury at its very inception, historically, I think, was overbroad as well. And so as we as conservatives move forward, I think we need to be very careful of that. And we need to continue and consistently call out the court when it issues opinions like this that are clearly antithetical to the text.
Exactly. And you're right. And that there is with regard to conservatives, there is after decades of this being the practice, it's easy for conservatives to fall into if these are the rules, I've got to play by them, or else, I don't get to play. And so, I don't think you can do it both ways. I don't think, and once again, this is a lay person looking from the outside, I don't think that you're going to be able to find a set of 20th or 21st century opinions that you can cobble together to come out with an opinion that accurately reflects the Constitution itself. I mean, that's what you're hoping for, even in situations where it might not benefit us in the short run. There has to be someone to argue for the Constitution and argue the Constitution as being law. The idea of constitutional law is a redundant situation with me. The Constitution is a law. You don't have to call it constitutional law. Just teach the Constitution. But once again, back to Professor Gallia's observation and experience, they are two different things. Constitutional law. When I used to teach the Constitution, I used to say we can look at this whole discussion in the terms of a case brought before the court, because we have constitutional law versus the Constitution. They're not the same thing. They are in conflict many times, and we've just got to decide as a republic, if we want to go with constitutional law or the Constitution. And once again, you brought up the idea of the church and just being told what to understand. Early in the history of the United States, don't want to go too far afield, but the Massachusetts colony put in place the old Deluder Satan Act, and it required communities to provide for education and reading so that people could read Scripture and would not be deluded by Satan, by various doctrines that had made their way into the organized church, the ecclesiastical hierarchy, for example. Same thing goes here. We've got to read and understand the Constitution so that we're not tossed about with every wind of doctrine, as you said, that comes down the pike from the courts. This idea, I think it was like independent legislative authority theory that the court struck down here. And just as a side to end this particular rant of mine, it's interesting to me that it's only the judiciary that can be independent. We can only talk about an independent judiciary. We can't talk about an independent legislature. We can't talk about an independent executive. Only the judiciary's actions cannot be questioned, and they have to be independent in whatever they decide to do.
And that means then we're really in a juristocracy instead of a constitutional republic, because then that has that entire attitude that you just described, and this difference between the Constitution as the supreme law of the land versus the body of constitutional law, and following man's opinions on the Constitution versus the text itself then means that we are beholden to the rule of the 9 robed justices, and whatever they say and whatever they decide they want to say and decide falls within their jurisdiction and purview. We then, in a constitutional republic that should have a separation of powers and checks and balances on those powers, are now beholden suddenly to these opinions that may be wrong. And you see this mirrored in the activist language that is not only in some of these opinions, but also from primarily the Democrat left, but even some Republicans who want outcome-oriented activism as well, which they shouldn't. We should be conservatives, originalists. But you see this even in the nature of the argument, for example, before Roe versus Wade was overturned. Well, this is supreme precedent. This is something that can't be overturned. I mean, they were making these arguments. And to your point, about how the media has covered this case about the electors clause, they're saying, and I was reading a piece from the Washington Post immediately after the opinion was read, just to see how they framed it. And it was the same thing that you just said, the independent state legislature theory. And it was like, oh, this theory was struck down as if it was just these Republicans who had this wild, perverse notion of something that they, created to advance their cause. And I'm thinking, no, this was an argument that was textual. It was based substantively in the article that apparently that the case was even discussing. And without respect to the ripeness or mootness of it, it was so fascinating to me to see that it was articulated that way, to say that, oh, these were just a bunch of lawyers that decided to, frivolously create this theory that the Supreme Court in all its wisdom, of course, rejected from these little state Republicans. I mean, that's how it was framed. And we have to reject that. And that's why it's so important that we know the substance of what the 7 articles in the Constitution and the 27 amendments actually say and what they mean in context. Otherwise, we are going to go the way of only listening to the doctrine of the people who have opined in the black robes. And so I wanted to shift then to this concept of judicial review and get your commentary on this, John, because this has been at the very inception of Marbury, I think has really gotten the court totally off track, and they are independent, and they take when they want to be, and they take this boundless power that the court in even 1965 in Griswold versus Connecticut literally said the court could read between the lines of the text of the Constitution and derive whatever they read into it and perceive as a right that emanates from the constitutional text, and then they have jurisdiction over whatever it is that they fabricated that they read. I mean, this is like, the emperor has no clothes, basically. I mean, this kind of same concept, but yet we as an American society think somehow that we're bound by these literal fabrications from the court. So what's your commentary on the concept of judicial review as a whole, and how can we start thinking about this from a better and more originalist perspective?
Well, the concept of judicial review, the actual phrase of judicial review, actually comes at the very beginning of the 20th century. And the individual that wrote on it actually wrote on, he originally referred to it as judicial superintendence. So the idea was, and sometimes we use the word judicial supremacy, but the phrase he used was judicial superintendence, which suggested that there was an Article 3 branch created that would superintend the operations of the federal government, including having effective veto power over really anything that the Article 1 or Article 2 branches did. Later on, he revised that phrase and referred to it as judicial review, which is very euphemistic. The idea that the court is going to come in and, John, you've done something, let's just review what you've done. No, that's not what this is. This is, we are going to either stop you from doing a thing, or we are going to order you to do a thing, which is what superintendence is you have now created a supreme body, the Article 3 branch, that can stop whatever it wants to stop, and to a great extent, it can't do this as well, but it can force the states, force the Congress, force the president to do a thing. And once again, that happens, well, on the federal level, it happens less frequently, mainly because the Congress does have the power over the purse. And if we want to turn the lights off, if Congress wants to turn the lights off at the Supreme Courthouse building, it will. And the court knows that. And every time it comes before the Appropriations Committee in the House to ask for money for the funding for the next year, it realizes that. So, but I'm only half facetious there. But the fact is that this is the case with judicial review, and we've got to get away from that, because that is not at all what the Constitution provides for. The framers were intelligent enough, were smart enough, and they gave their political posterity enough credit to know if they wanted to make one branch of the government all powerful, we would have seen that in the document itself. Now, Madison said in one of the Federalist Papers, he said, in Republican government, the legislative authority necessarily predominates. And if we look at the product that he and his fellow delegates put forward, Article 1 is Article 1. It's the longest article. It is authorized to remove from office all the other federal officers. No one can touch. The court can't touch a member of Congress. The president can't touch a member of Congress in their official capacity as members of Congress. But the Congress can impeach and remove the president, the vice president, the justices, judges, and the like. And only members of the House can remove members of the House. Only the senators can remove a colleague that is of ill behavior. So we've got to get back to this idea. So judicial review is a euphemism. We've got to reject it out of hand, because otherwise, as you say, now what's the word you use? You've used it. I've got to get this word right. Judicial. The
juristocracy.
Juristocracy. Exactly. That's great. I'm going to plagiarize that often. The juristocracy.
Well, then I'll give credit to our mutual friend Mike Donnelly, who's a good friend. That was actually his creation, and I've borrowed it from him. So, and I think it's very apt.
I think you're exactly right. That's what we're living under, and presidents from Jefferson to Lincoln said this is not. Both of which were lawyers, said we can't have this. We can't have the courts with this ultimate opinion. They're unelected. They're to a great extent unaccountable, and we can't. The Constitution doesn't provide for that, and we as the custodians of our constitutional their constitutional legacy we are bound to make sure that doesn't happen, in my opinion.
Absolutely. And this is where, if we understand what the separation of powers genuinely meant and why the founders debated and discussed all of these ideas during the Constitutional Convention and produced our U.S. Constitution in its original form, and then gave us Article 5, the process by which we can amend the Constitution. We can change what powers are delegated to specific branches. We can remove them. We could add more. We've amended the Constitution 27 times in our nation's history. Some of those have been good. I'm glad I can vote as a woman. Some of those haven't been so good. I think that our method to elect U.S. senators by the popular vote, instead of having them appointed by the state legislatures, removed that element of accountability to the states from the Senate. And when we see how the House and the Senate are supposed to be the bicameral nature of those houses on the federal level, there's a reason why all of these nominations have to pass the Senate. Well, why? Because they were beholden to the state legislatures, not just to the people. So there was a purpose and a reason. And so some of these amendments, I think, were not crafted well and did not help the system of government move forward to best preserve and protect our rights. But the founders knew that they may not get it totally right the first time. And that what they wanted to do was build the best possible system to fulfill the mandate of the Declaration, which which is to preserve and protect the rights that we, the people, have from God, our creator, that we didn't give over any of our rights or our power to the government other than what the Constitution specifically enumerates and grants. And then on the state level, of course, through the 9th and 10th Amendment to the state constitutions. But that, as we mentioned, the Supremacy Clause can't be in contradiction. Otherwise, we're not a United States. We're just more like a European Union with very, very weak federal sovereignty. And that's what the Articles of Confederation had done. And that's what our founders, thought that we needed a stronger federal government, but not to override state sovereignty. So, so all of that to say, none of that, by the way, is taught in law school. I didn't learn any of that through my professors, through taking the bar, through practicing in substantive areas of constitutional law. I mean, all of this, I would encourage everyone, read the Federalist Papers, read the Constitution for yourself. I have a little app on my phone. It's not very long, but go through it and just see substantively what powers are actually given to the federal government, because then we can look at Article 3. We can look at the concept, and I think your term for that as being a euphemism for judicial review is very well put. Because we can see that that's truthful, that's faithful to the text, and we can start to combat a lot of these very bad opinions from the Supreme Court or executive orders from the executive or some of these creatures of the legislature that really are beyond the scope of even congressional authority on the federal level. And we can do that by using the rule book. And so I think it's so important for conservatives to not buy into this myth that the federal government should or can solve all of our problems. We have to get back to understanding state sovereignty, and we have to get back to understanding what Justice Scalia said so beautifully in front of Congress many years ago, when he said that that the best way that America preserves freedom and liberty isn't because we have a Bill of Rights. Every banana republic has a Bill of Rights, and even longer than what we have. It's our separation and limitation of powers given to the government. And that's what Chief Justice Roberts and his cohort of these 6 justices completely ignored in this opinion and in many others. And so, I think that Article 5 gives us a solution, but in your view, John, what is the best solution for people who want this type of education? And I hope that they will get that and they'll be encouraged to learn about the Constitution, not just constitutional law. But what can we actually do as a nation and as we the people to get back to the original text of the Constitution and start trimming back what has become just a behemoth of a federal bureaucracy and what we're now terming a juristocracy, which really means that we are ruled by a Supreme Court instead of being a nation of rules and having our court under and derived from Article 3.
Right. Well, we've got to those 2 sources that you mentioned, the Federalist Papers, the Constitution. I remember when I was still in Congress, one of the teachers of my children in high school, a government teacher, would have me come from time to time and speak on the Federalist Papers. And it's kind of like reading scripture. It's an older type of talking. I don't know if I would necessarily go for a new revision, like the New International Version of the King James Version when it comes to the Federalist Papers. But it is important. I look at them as the the book that you put in the owner's manual for the Constitution, like you have in your car in the glove compartment. That to really understand what's going on in the Constitution, the Federalist Papers are very helpful in that. And but the wording of the Constitution is pretty clear. Jenna, one of the most important things, as you know, that sets us apart, or really set us apart in 1789, was a written Constitution. To this day, Great Britain, the United Kingdom, does not have a written Constitution in the same form we do. In fact, shortly after the debacle in Iraq panned out for the United Kingdom and Tony Blair was forced to leave, the Labour Party leader at that time said, one of the pillars of his plan to keep labor in power was to create a written constitution. In 2005, this was about 2007, 2008, Great Britain was saying, hey, we're going to get a written constitution. Now, it hasn't come to pass, and their quote-unquote constitution is based on, judicial precedents, parliamentary statutes, traditions, and the like. But they don't have what we have. And they don't have the elegance, obviously, that our framers gave us in that important document. You and I could look at it today and we could say, justices, respectfully, you just need to read the whole thing. If you read the whole thing, you'll find out why the North Carolina legislature gets to do this, and their state courts don't get to second guess them. It's just as clear as day. So read the Constitution. The Federalist Papers are a great backup. I have a book on the Constitution, as you mentioned earlier, Ordained and Established. So those are where we need to go and find out what this is that we have gotten. But first and foremost, it's like my book is a commentary on the Constitution. I would not put anybody tell anybody to read a commentary on Scripture before they should read Scripture. And so knowing the Constitution is vitally important to our political destiny.
So well said, and I could not agree more. And for everyone out there, if you really want to change our country back into its original condition, and you really want to preserve and protect our union and make sure that we are preserving and protecting our ability to exercise our rights and move forward, creating a more perfect union, we have to first know what our rule book says. I mean, I've analogized this to a game board where, my family, we're all nerds and we love playing board games. And my parents have a game closet. And if you go to that game closet, you have to pull out different games, and they all have different rules and different ways that you win the game. And in order to play the game well, you have to know the rules. You have to know how to move on the board, what moves have certain consequences, what you can and can't do. Do you roll dice? Do you pick up a card? I mean, there's all kinds of different things that govern that specific game that you're playing. And it's the same thing in the context of our Constitution. That is our rule book that designates what can Congress do, what can the executive branch on the federal level do, what can and cannot the federal judiciary do, what can the states do, what rights and what powers are actually reserved to we the people. No one ever talks about that. They always say the powers to the federal government and to the states, but the 9th and 10th Amendment say the powers that are reserved to the states or to we the people. We actually have power of civil government ourselves in certain areas that are not specifically given to the federal government or reserved to the state government. And we have to know what that is, because if we just go about philosophizing and saying, well, I don't like how this is done, well, we're not then appealing to a violation of a specific rule. And we're not actually enforcing anything in a meaningful way if we don't actually know what the rule book says. It's the same thing, again, as we're comparing this to reading Scripture. You can be as passionate as you can possibly be about our Lord and Savior, Jesus Christ, but that doesn't mean that you have knowledge of the truth. And the Bible specifically tells us, grow in the grace and knowledge of the truth so that we don't buy into false doctrine. We don't believe false things about the person of God and truth, or how we are to conduct ourselves as Christians, or the authority that Christ as the head of the church has given to the church. We need to be aware of these things. We need to know what the rule book says. So absolutely, we need to start with our rule book, and then the Federalist Papers that give us kind of that legislative history. Why did the founders debate certain things? What were the Federalist Papers concerned with in terms of advancing an argument for ratification of the U.S. Constitution? That's all the Federalist Papers are. And then there's the Anti-Federalists that saw some weaknesses, and you can read those too and see what was the clash, the back and forth, because so many people say, well, the U.S. government is the best that was ever designed. Well, why? Is that argument, or is that a basic assumption because we're Americans? Could it have been better? What were the arguments? We need to know that. Then we can read the commentaries. And, your book is excellent. I also wrote a commentary called The Legal Basis for a Moral Constitution. And this is about the philosophy and then the mechanics of the Constitution. I would commend that to the audience as well to read. But we have to grow in the knowledge of our system of government if we want to meaningfully push back against an overriding oppressive government. Our founders weren't just these, wonderful torch-wielding villagers that decided to rise up in rebellion. I mean, they knew substantively about political geography. They knew about law and jurisprudence. They understood, and I would commend, and this is my little tangent of wonky, Federalist 84 is my favorite from Alexander Hamilton, because he argued that we don't even need a Bill of Rights, because there was no power that's given by the Constitution to the federal government to even decide or infringe upon rights like the freedom of the press, free exercise of religion. And his argument ultimately was overridden by James Madison. And I think that was actually a good thing for America's history. But his argument was still very well put, that in the sense that Bill of Rights were originally ordained, and you mentioned, in England, for example, in their system, so many of the world's governments previously had a Bill of Rights because the people, in order to have protection from their government, would basically turn over all of their rights. And then somebody along the way was like, well, wait a minute, we need to reserve some rights that the king or the system, the parliament, can't infringe on. So they created a Bill of Rights that reserved rights to the people. Well, here we have the exact opposite system. We haven't given any of our rights to the government. We've given the government specific, limited, separated powers by which to protect and preserve our rights. And Hamilton makes a beautiful argument for that in Federalist 84, that I think we as citizens of this great country, and especially lawyers who may be listening to this, who litigate in this area, we need to know substantively why we have a constitution that doesn't give power over to the Congress to infringe on any of these rights. And we have to advance those arguments, not only in courts of law, but also in the court of public opinion, if we are going to make any kind of difference to continue on with this great experiment. So really, really well said, John. And just closing thoughts from you as well, in terms of, where we go from here, and kind of just, looking around at our culture, do you have hope that we can get back to an originalist view in our culture? Because it's incumbent upon us as we the people to take hold of this education and understand our rule book so that we can go out and enforce it and teach others.
Well, I do have hope. With 4 children and 7 grandchildren, I do have to have hope. And I believe that, but that's going to come from us. It's going to come from we the people, and it's going to come from, quite honestly, a church that becomes more knowledgeable about it. We have the Apostle Paul, writing to the church in Rome, said, the powers that be are ordained of God. The powers that be, when you read the preamble to the Constitution, you realize that the Constitution is essentially the powers that be. At the time that Paul wrote that to Rome, Roman citizens had to give an oath to the emperor, to Caesar. Their oath, their fealty was to Caesar. In the Constitution, members of government, 6 times I had to swear an oath to uphold the Constitution. I did not make an oath to a person. The powers that be, the forces that govern us in the United States of America, are provided in the United States Constitution. And they are going to be, we are their caretakers. It's up to us. Many people much smarter than I have observed that, without our giving life to the Constitution, I'm not talking about a living Constitution. I'm talking about us making the Constitution real. It's up to us. We have got to preserve it. If it's not preserved, if there's not fidelity to the Constitution, it's because we, the people, have handed it over to, as you mentioned earlier, 9 unelected, unaccountable persons in black robes to care for our constitutional freedoms, our constitutional well-being, and that was never intended. That was never intended, and we've got to get back to a citizen legislature, if you will, and I don't mean in a formal sense, but we've got to keep track. I remember I had when I first got elected, there was an individual in the district at the time who had worked so hard to get someone else elected in that. And she came to me one time and she said, I always contacted your predecessor. And I don't have to worry about you, John. I know you're always going to do the right thing. I said, no, do not do that. That you can't stop doing what you've been doing, because quite honestly, what she had been doing all those years ultimately gave way to a new person to take that office. So we've got to be zealous. We've got to it's up to us to, our framers, the framers did what they did for their posterity. It's up to us to do likewise for our posterity. And if we lose it, it will not be because folks like Hamilton and Madison and Franklin and Washington didn't do their job. It's going to happen because we haven't done ours. And so I would just say that that is what we've got to do. We've got to resolve to be faithful to the Constitution and to hold others accountable for when they deviate from its principles and from its clear wording.
Yes, we have to have accountability, and as citizens, make sure that we have great people like you and others who care about this and are knowledgeable about it in office, and to commend and support those who are doing the right thing, even if it isn't the outcome we prefer. Like Thomas Massie, for example, is one of the people that I most respect right now in Congress because of his fidelity to the Constitution. And even if he votes against what would otherwise be a great Republican outcome, he wants to be a textualist, and that is a very good thing, and limit himself to the text of the Constitution. And we should support any of our office holders on the federal level or the state level and a local level when they do hold themselves to that accountability, and we should support that. So really appreciate it, John. And your book is ordained and established, and I would highly commend that to everyone's reading. And also, of course, the U.S. Constitution, the Federalist Papers. You have a long weekend heading into the 4th of July, and what better way to start with the Declaration, the Constitution, and do some light reading over the weekend. So thanks so much, John. Really appreciate your time.
Thank you, Jenna.
With inflation, the banking world collapse, and everything that Joe Biden is doing not to protect America, you need to make sure to secure your financial health, especially in retirement. And hey, if you're a millennial like me, that actually is sooner than you think. You need to start now, even if you are a millennial or a Gen Zer, to make sure that your financial health is actually healthy when we get to retirement. And Legacy Precious Metals has a revolutionary new online platform that allows you to invest in gold and silver online in real time. In a few easy steps, you can open an account online, select your metals of choice, and choose to have them stored in a vault or shipped right to your door. You'll have access to a dashboard where you can track your portfolio growth in real time anytime. You'll see transparent pricing on each coin and bar, and this puts you in complete control of your money. The platform is free to sign up for. Visit legacypminvestments.com and open your account and see this new investing platform for yourself. Gold hedges against inflation and against a volatile stock market. A truly diversified portfolio isn't just more stocks and bonds, but different asset classes. This brand new platform allows you to make investments in gold and silver, no matter how small or large, with just a few clicks. Visit legacypm.com to get started. You can download the free investor's guide, and you can also call Legacy PM Investments to talk to a portfolio expert to get expert answers to to customize your personal portfolio. So visit legacypminvestments.com to get started. Tell them that Jenna sent you.
Have you ever picked up a towel set because it felt so soft in the store, but then when you leave and you go to use it, it's not really that absorbent? It's basically a towel that is leaving you out to dry. That's why MyPillow has developed the MyPillow towels that actually work. I know, it's totally mind-blowing. Towels that actually dry you. Their 6-piece towel set includes 2 bath towels, 2 hand towels, and 2 washcloths. They come in a variety of colors, I have the sage green and the white. I love them. And right now you can receive a 6-piece set for only $39.98 with promo code Jenna. That's JENNA. So go to mypillow.com right now and click on the radio listeners special. MyPillow products come with a 10-year warranty and have a 60-day money-back guarantee. So to receive this amazing offer on the 6-piece towel set of MyPillow towels, just go to mypillow.com, click on the radio listener special, and enter promo code Jenna, that's JENNA, or call 1-800-564-8475. That's mypillow.com, promo code Jenna.